Good afternoon. Our topic for today is Title 5 on Civil Liability. You know already when we had Article 15 on the persons that are criminally liable. So by this chapter or by this title, you will learn who are the persons civilly liable for committing a felony. The law justifying the civil liability of a person criminally liable is Article 100, which provides that every person criminally liable for a felony is also civilly liable. Remember that when a person commits a crime, he is not only committing the same against a particular person or the offended party or to the state. On the other hand, the basis in Article 100 is that when a person actually commits a crime, he is not only committing a transgression of the law against the state, but as well to the private offended party. Hence, the injury can be classified to social injury and personal injury. The social injury is produced by the commission of the accused of an overt act that disturb or transgress the peace of the community or the society, and alarms of which as a result of the overt act he commits. As far as the private offended party is concerned, he likewise incurs a personal injury to the private offended party, either to his person or to his property. It might also be his honor as well as against her chastity. While the social injury is sought to be repaired through the imposition of the penalty. That's why if a person, when he will be found guilty beyond reasonable doubt, he will be imposed a penalty. On the part of the personal injury sustained by the private complainant, he has to indemnify, which is civil in nature. So to illustrate, A was convicted of less serious physical injuries through negligence, and the court imposes upon him a straight penalty of 1 year and was ordered to pay 10,000 in actual damages and 10,000 as exemplary damages to B, the injured party. In other words, the consequence of the social injury that he caused is the imposition of the straight penalty of 1 year, and the personal injury is the payment of the actual and exemplary damages by the accused. What are the damages that may be recovered in criminal cases? In crimes against property, the damages that a person may be required to pay, the accused may be required to pay, are the damages based on the price of the thing and its sentimental value to the injured party if the thing cannot be restored. Meaning to say, if you have there a crime for malicious mischief, which is a crime against property, considering that the accused was found guilty beyond reasonable doubt of damaging, for example, the property of another, and it cannot be restored, he will be required to pay for its price, the actual price. And you also have there, and its sentimental value to the injured party. Now, what if the crime charged against the accused to which he is found guilty is a crimes against person, like physical injury. He will be required to pay actual damages for the injury sustained. Example, the money he spent for his medication. You also have their unearned income or lost income because of the injury he sustained. He failed to perform his task. Hence, he was not able to earn a living during those periods that he was still recuperating of the injuries he sustained. Now, in case of death, there could be burial expenses. You also have their damages for loss or impairment of earning capacity in cases of temporary or permanent injury. Meaning to say, because of the injury he sustained, let's say his fingers or his hand was cut, meaning to say, there would now be impairment of his earning capacity. So, reasonable damage for such loss or impairment can be given by the court. You also have their moral damages and exemplary damages. Now, take note that in case of death caused by a crime, the moral damages that can be awarded by the court is 50,000. In addition to the following, the defendant shall be liable for the loss of the earning capacity of the deceased, meaning to say, if the deceased was still young, earning for a living, the court can actually compute it based on the life expectancy of the victim vis-a-vis the amount of money that he is actually earning prior to his death, so that can be computed by the court. He shall be liable to give support if the deceased was obliged to give support. So in lieu to that responsibility of the accused, the offended party can actually ask such support from the accused who caused the death of the deceased. Now, this is especially true if the deceased was actually giving support to a person who is not an heir of the deceased. He shall pay moral damages for mental anguish. But if there is no damage caused by the commission of the crime, the offender is not civilly liable. Example, treason, rebellion, direct assault. So no damages can be awarded on those crimes. Now, Article 100 says that every person criminally liable is also civilly liable. Now, question, what would happen if the accused or if the person is acquitted? Does it mean to say extension of his civil liability as well? Civil liability is dependent on the reason of the acquittal. So in other words, he may still be required to pay. The revised rules of criminal procedure provides the extension of the penal action does not carry with it extension of the civil. However, the civil action based on the delict shall be deemed extinguished if there is a finding in a final judgment in the criminal action that the act or omission from which the civil liability may arise did not exist. In other words, there is really no basis to award any civil liability because the acquittal of the accused was based on the failure of the prosecution to prove his guilt beyond reasonable doubt. Like, he was not responsible to the commission of the act. He was not the perpetrator to the injury sustained by the private complainant. In other words, there is really no basis to which the civil liability may be awarded to. You have there the exception. Independent civil action. So that is the ICA there, independent civil action. Remember that the extension, the basis that a person cannot be made civilly liable if he was acquitted, that is limited only to the civil action based on the delict, meaning to say based on the crime alone. In other words, if there are reasons that you could make him liable other than the delict, other than the criminal act he commits, then you can make the person civilly liable. So example of an independent civil action, you have therefore breach of contract, criminal action for estafa to be specific. Okay, in a criminal prosecution for estafa, it could be possible that the guilt of the accused was not proven beyond reasonable doubt. However, during the prosecution, it was established that indeed the accused received this money from the offended party, to which he cannot anymore give back to the private offended party the amount that he received, or he also failed to return, if any. Now, it could be possible that with that, the prosecution was able to establish that indeed the private complainant received the amount. However, for purposes of making him criminally liable, the prosecution failed to prove that when the accused received the money from the offended party, he committed it with deceit. Okay, deceit is one of the elements of estafa that the prosecution needs to prove so that the person can be made criminally liable for estafa. Now, considering that the prosecution failed to prove deceit on the part of the accused when he received the money from the private complainant, there is no way that the accused can be made criminally liable. The possible verdict that the court will give to the accused is acquittal on the criminal aspect, but the court could still make the accused civilly liable. That is possible. He was acquitted, yet he can still be made civilly liable. But if the private offended party reserves the right to prosecute separately or to file an action separately from the criminal aspect, he may do so. Okay, so that is an example as example of the exception that even if the person is not criminally liable, he could still be civilly liable, because what is extinguished in case the person was acquitted, if his guilt was not proven beyond reasonable doubt, the extension there is on the civil liability based on the delict alone. Okay, delict alone. So if there are other bases to which he can still prosecute the case, like the independent civil action, then the offended party can still proceed with filing a separate civil action. Same with slight physical injury or less serious physical injury. So based on that article, I think 31, 32, 33 of the Civil Code, those are the pertinent provisions wherein you can make the person civilly liable, independent or separate from that of the criminal prosecution. So further example or illustration on civil liability, although the accused was not held criminally liable or he was acquitted. Acquittal on reasonable doubt. When the accused in a criminal prosecution is acquitted on the ground that his guilt has not been proven beyond reasonable doubt, a civil action for damages for the same act or omission may be instituted. That was actually our example earlier. Same with the other one on non-imputability. Acquittal from a cause of non-imputability. The exemption from criminal liability in favor of an imbecile or insane and a person under 15 years of age or over 15, less than 18, acting without discernment, and those acting the compulsion of an irresistible force or under the impulse of an uncontrollable fear, no criminal liability. But the exemption is limited only to the criminal liability. It does not include the civil liability. So if you can recall in Article 12, while the person is exempted from criminal liability, it does not carry with it his exemption from civil liability, except what paragraph? Paragraph 4 and paragraph 7. Acquittal in the criminal action for negligence does not preclude the offended party from filing a civil action to recover damages based on a new theory that the act is a quasi-delict under Article 2177 of the Civil Code. Or when there is only civil liability, so this is the one I mentioned earlier on STAFA, it's only civil liability. And then independent civil action, ICA, under Article 31, 32, 33, and 34 of the Civil Code. An acquittal in a criminal case is not evidence of innocence in subsequent civil action based upon the alleged criminal act. Remember that the degree of evidence required is not the same. In criminal action, you have to prove his guilt beyond a reasonable doubt, while in a civil action, preponderance of evidence is sufficient. So who shall be civilly liable? Under Article 101, the exemption from criminal liability established in subdivisions 1, 2, 3, 5, and 6 of Article 12 and in subdivisions 4 of Article 11 of this code does not include exemption from civil liability, which shall be enforced subject to the following rules. Okay, so who can be made civilly liable? First, in cases of subdivisions 1, 2, and 3 of Article 12, the civil liability for acts committed by an imbecile or insane person and by a person under 9 of age or based on RA 9344. So you have there a person 15 years old and below or over 15, less than 18, acting without discernment. So who can be made civilly liable? It shall devolve upon those having such person under their legal authority or control. So if you have there the parents of this child at risk, because we cannot consider them to be a CICL because they have no criminal liability. So if you have there the parents, then the parents can be made civilly liable. Absence of the parents, you have there the legal guardian. Unless it appears that there was no fault or negligence on their part. So that is their defense, so that they cannot be made civilly liable. Should there be no person having such insane, imbecile, or minor under his authority, legal guardianship, or control, or if such person be insolvent, said insane, imbecile, or minor shall respond with their own property. Okay, own property, except property exempt from execution in accordance with the civil law. Next, in cases falling within subdivision 4 of Article 11, the person for whose benefit the harm has been prevented shall be civilly liable in proportion to the benefit which they may have received. So the example that we have with this last time is on the act of the ship captain ordering to jettison some of the cargoes to unload to lessen the weight of the ship so that it can pass through the storm. So who will be required to pay? The owner of those cargoes that were not jettisoned. To whom they will pay? To the owners of the cargoes that were jettisoned. When we say jettisoned, those that were thrown away from the ship. The court shall determine in sound discretion the proportionate amount for which each one shall be liable. When the respective shares cannot be equitably determined, even approximately, or when the liability also attaches to the government or to the majority of the inhabitants of the town, and in all events whenever the damages have been caused with the consent of the authorities or their agents, indemnification shall be made in the manner prescribed by special laws or regulation. Third, in cases falling within subdivision 5 and 6 of Article 12, so those persons using violence or causing the fear shall be primarily liable and secondarily, or are primarily liable and secondarily, or if there be no such person, those doing the act shall be liable, saving always to the latter the part of their property exempt from execution. So general rule, who will be liable? The person who uses force or violence upon the other accused, or to the person who intimidates to compel one or to force one from committing an offense. So they are the persons primarily liable, secondary na lang si accused. Again, remember that one who were compelled or forced to do an act may be exempt from criminal liability but not civil liability, secondarily liable. Exception. There is no civil liability in paragraph 4 of Article 12, which provides for injury caused by mere accident, and we're done with this. There is also no civil liability in paragraph 7 of Article 12, which provides for failure to perform an act required by law when prevented by some lawful or insuperable cause. So, if you have there the CICL, the person criminally liable, so who shall be liable? The father and mother shall be subsidiary liable. Then you have there the guardian in case of absence of the mother or father. What do we mean by subsidiarily liable? Automatic. Automatic. Because you have there the crime committed by the CICL, automatically, even if the mother or father are not accused, they are liable. They get in or they put themselves into the shoe of the CICL. So they are subsidiary liable. The final discharge of a CICL does not obliterate his criminal liability. The discharge referred to here is the discharge of the CICL of as far as the criminal aspect of the case is concerned. So he may have been through with the reformation or the training to which he was placed in the institution who prepared him for reintegration. So he might have been reintegrated into the family or to the community, and a final discharge was issued in his favor after he availed of suspended sentence. So that is limited only to the criminal aspect. He will still be required to pay for the civil liability. 102, who are liable? In default of the persons criminally liable, innkeepers, tavern keepers, and any other persons or corporations shall be civilly liable for the crimes committed in their establishment in all cases where a violation of municipal ordinances or some general or special police regulation shall have been committed by them or their employees. So in Article 102, this presupposes that the accused was an employee. And because the employee is insolvent, he cannot meet the civil liability then his employer, this innkeeper, tavern keeper, or proprietor of the establishment to where the crime was committed, while the accused was in the performance of his duty, for example. So the employer shall be subsidiary liable. They are liable even if they are not the accused. But since the accused is under their supervision at the time of the commission of the offense, they are subsidiary liable. Innkeepers are also subsidiary liable for the restitution of goods taken by robbery or theft within their houses, from guests lodging therein, or for the payment of the value thereof, provided that such guest shall have notified in advance the innkeeper himself or the person representing him of the deposit of such goods within the inn, and shall furthermore have followed the directions which such innkeeper or his representative may have given them with respect to the care and vigilance over the goods. So what do we mean by this? So I think you have tried checking in a hotel, and then they have there, we are not liable for the loss of any things. So keep your things. No. Do not keep your things unattended. Okay, so despite the putting of those signages, they are subsidiary liable. Okay, for as long as you notify them of the said goods in the vicinity. Now, exception. When could this innkeeper be exempted from criminal liability? No liability shall attach in case of robbery with violence against or intimidation of persons. So that is the general rule. In case of robbery, of course, the life of the employees is more important than the goods or the things. Exception to the exception. Unless committed by the innkeeper's employees, they cannot be exempted from civil liability if it is an inside job. To illustrate, if homicide is committed in an inn or bar on a Sunday, which according to the ordinance should be closed, since the innkeeper in this case violates the ordinances by opening his establishment for business on a prohibited day, he shall be subsidiary liable for the indemnity or civil liability to the heirs of the deceased. In such case, the innkeeper or owner of the establishment is civilly liable for such crime committed therein if the offender is insolvent. We can simplify this by saying common responsibility. 103. Subsidiary civil liability of other persons. The subsidiary liability established in the next preceding article shall also apply to employers, teachers, persons, and corporations engaged in any kind of industry for felonies committed by their servants, pupils, workmen, apprentices, or employees in the discharge of their duties. Now remember that in case of a crime committed by the employee or the student, for example, the person who shall be criminally liable is the student or the employee. But what we are talking is on the civil liability. Now, even if the employer, the teacher, is not the person criminally liable, but the law expressly said that they shall be made civilly liable subsidiarily in case of insolvency of their employees or students. Reason, you have their common responsibility. What shall be done? Because this employer might say, I was not given due process. I am not the accused. I did not participate in the criminal case. So all we need to do, if you are the prosecutor later on, whether public or private, you must notify this employer, especially kanang mga driver involved in reckless imprudence cases. I always see to it that the employer, the driver, if the driver is an employee, I will have the employer notified of the hearing. I will require notice that be sent to them so that they will be notified. In fact, if they could appear during trial, then much better. So all we need to do is to notify them. They need not be heard during trial because the criminal case is against the employee or the student for that matter. So for 103 to apply, the employer, teacher, person, or corporation is engaged in any kind of industry, meaning to say, they must be engaged in any kind of industry. That any of their servants, pupil or student, workmen or employee, apprentices, or employee commits a felony while in the discharge of their duties. That said employee is insolvent and has not satisfied his civil liability. So the employer, teacher, person, or corporation shall be made civilly liable by way of its subsidiary liability. To illustrate, a workman of a construction company stole some things while he was making mirror repairs in a house, and after being prosecuted was found guilty by the court. The workman cannot satisfy his own civil liability, so there is that imprisonment imposed upon him plus the civil liability. However, he cannot satisfy because he is insolvent. So the company is liable subsidiarily for the restitution of the things or for the payment of their value. When we say industry, because one of the elements says there that the employer or the teacher, who else was that, must be engaged in any kind of industry. So industry refers to an enterprise not conducted as a means of livelihood or for profit, does not come within the meaning of the term business. Trade or industry. So industry, not an enterprise not conducted as a means of livelihood or for profit does not come within the meaning of the term business, trade, or industry, but industry is any department or branch of art, occupation, or business, especially one which employs so much labor and capital and is a distinct branch of trade. Hence, a person who owns a truck and uses it in the transportation of his own product is engaged in industry. Now, how about in the hospital? Hospital is not engaged in industry. Nurses are not the servants of the hospital. Doctors are not employees of the hospital. Now, they are employed to carry out the orders of the physician. We're talking about nurses, to whose authority they are subject. So, if the nurse commits a criminal act, you cannot make the hospital subsidiary liable. If the doctor commits a criminal act, you cannot make the hospital subsidiary liable in case of insolvency of these people, because they are not actually, they have no employee-employer relationship. Private persons without business or industry, like a private driver, not subsidiary liable. Decision convicting an employee is binding upon the employer with respect to the civil liability and its amount deemed written into the judgment. So what do we mean by this? That the subsidiary liability of the employer need not be expressly stated in the judgment because the law expressly provides it is deemed instituted, deemed written into the judgment. So to enforce it, you have to file a motion for subsidiary writ of execution. Now, what civil liability includes? It shall include restitution, reparation, indemnification of consequential damages. So let's take them one by one. When do we say restitution? When shall there be reparation? When shall there be indemnification? Or what are your basis in restituting, in reparation, or in indemnification? Now, in crimes of theft, the culprit is duty-bound to return the property stolen, the subject of the taking. You have to return the very same thing, subject of the taking. Now, what if you cannot return the thing, subject of the taking? That's where reparation comes in. In case of inability to return the property stolen, the culprit must pay the value of the property stolen. In case of physical injuries, the reparation of the damage caused would consist in the payment of hospital bills and doctor's fees to the offended party. That is reparation. How about the indemnification of consequential damages? So what is included there on that indemnification is the loss of his salary or earning as a consequence of the crime committed by the accused to the offended party. Now, in Article 104, it provides for 3 forms of civil liability. And in Article 38, if you can still recall, it provides for the order of payment of pecuniary liability. Okay, order of payment of the pecuniary liability. So both articles include reparation of the damage caused as well as indemnification of consequential damages. While civil liability include restitution, pecuniary liability do not include restitution because the latter refers to liabilities to be paid out of the property of the offender. In restitution, there is nothing to pay in terms of money, as the property unlawfully taken is returned. Pecuniary liability include fine, cost of the proceeding. Civil liability do not include them. How restitution is made? The restitution of the thing itself must be made whenever possible. So meaning to say, the very same thing that was taken must be returned with allowance, of course, for any deterioration or diminution of value as determined by the court. The thing itself shall be restored even if it be found in the possession of a third person who has acquired it by lawful means, saving to the latter his action against the proper person who may be liable to him. This provision is not applicable in cases in which the thing has been acquired by the third person in the manner and under the requirements which by law bar an action for recovery. What is that instance? Bought from public auction. Okay, that's the only thing wherein you cannot recover the thing if it is already in the hands of a third person. We are referring to the buyer in good faith in a public auction. If the third party or the innocent purchaser did not bought it from a public auction, then he must return the same because the thing to which he is in possession thereto is subject of the taking. So if you are there the third party, what would be your remedy? You go after the accused. Okay, you go after the accused. Now, if you will be asked, what if I will not return it? I am a third party. Probably, you will be charged under PD 1612. Remember anti-fencing? What if the crime is malversation? Or is Article 105 properly applied to the forfeiture of the house built with the money malversed by a public officer? In the case of Garcia versus Bituin, said principle was applied, the CA applied Article 105 to the forfeiture of the house built with the money malversed by a public officer, with allowance of any deterioration or diminution of value. The return of the thing, an accused will be ordered to pay such amount representing the deterioration. Why will he be made to pay? Because presumably, when he was in possession of the thing, subject of the taking, he might have used it and it deteriorated. That's why he will have to pay said amount to address deterioration. The general rule is that the owner of the property illegally taken by the offender can recover it from whomsoever is in possession thereof. Okay? Even to a person who has acquired it by lawful means. But who is this person? The thing itself shall be restored even though found in the possession of a third person who has acquired it by lawful means. Thus, even if the property stolen was acquired by a third person by purchase without knowing that it had been stolen, the property shall be returned to the owner, and he shall not be required to pay reimbursement. If the thing is acquired by a person who knows it to be stolen, he is an accessory, and he is also criminally liable. So you have the PD 1612. But if from public sale or public auction, meaning to say, he bought it from a public sale or public auction, plus he is in good faith, that is the time that he can ask for reimbursement because he is a innocent purchaser and in good faith. To illustrate at a public sale and in good faith. So you have there Varela versus Finnick. A was convicted of estafa for having pawned the jewels which had been given him by B to be sold on commission. Having found that the jewels had been pawned by A to a pawn shop, B filed a petition in court to require the owner of the pawn shop to restore the jewels. How did the court rule? The owner of the pawn shop may be obliged to make restitution of the jewels because although he acted in good faith, he did not acquire them at public sale. So, the private complainant can ask for the third person can only ask for reimbursement if he is a buyer in good faith from a public auction. The court which convicted the accused of estafa may summon the owner of the pawn shop and after hearing him, order the return of the jewels pawned to him without reimbursement of the amount of the pledge. The pawn shop owner may seek his remedy from the person who pawned the jewels. May restitution be ordered even if accused is acquitted? Restitution may be ordered even if accused is acquitted, provided the offense is proved and it is shown that the thing belongs to somebody else. As a rule, if the accused is acquitted, the court should not order the return of the thing to its alleged owner. But if it is shown that the ring belonged to and was in possession of somebody else and that it was stolen from him, but the identity of the thief was not established by the prosecution and the accused pawned it in the pawn shop from which it was recovered, the court should order its return to the owner. In this case, the offense was proved, but not the identity of the offender. Is restitution limited only to crimes against property? As a rule, yes. Okay, as a rule, yes. When a crime is not against property, no restitution or reparation of the thing can be done. But in treason case, the defendant was ordered to return the 3,900 to the person from whom he took the same when he committed the treasonous act. In an abduction case, the defendant were ordered to return the 10 pesos taken by them from the offended girl. How to do reparation? The court shall determine the amount of damage, taking into consideration the price of the thing whenever possible, and its special sentimental value to the injured party, and reparation shall be made accordingly. Reparation will be ordered by the court if restitution is not possible. Thus, when the stolen property cannot be returned because it was sold by the thief to an unknown person, he will be required by the court, if found guilty, to pay the actual price of the thing plus its sentimental value to its owner. If there is no evidence as to the value of the thing unrecovered, reparation cannot be made because there's no basis. So what shall it includes? In a robbery case, the repair of the material damage caused by the robbers in breaking doors, wardrobes, and others, in addition to the value of the thing taken, may be assessed and included as part of the reparation to be paid by the robbers. In a rape case, the accused was ordered to pay the value of the woman's torn garments. This is reparation, which is distinct from the indemnity. Civil damages are limited to those caused by and flowing from the commission of the crime. Payment of the insurance company does not relieve the offender from his obligation to repair the damage caused. Indemnification. What includes? What is included in indemnification? Indemnification for consequential damages shall include not only those caused the injured party, but also those suffered by his family or by a third person by reason of the crime. Indemnity generally refers to crimes against person. Reparation is referring to crimes against property. Because in crimes against person, you have to indemnify the consequential damages. But in crimes against property, you have to do reparation. You have to return the very thing itself. Example, in a physical injury case, the injured party is entitled to be paid for whatever he spent for the treatment of his wounds, doctor's fees, and for medicine, and furthermore, his salary or wages unearned by him because of his inability to work due to the injuries received by him, the damages sustained by him because of the loss of a limb, or the lessening of his earning capacity. So I have here an illustration on indemnity in case of death. So remember, I mentioned earlier 50,000. Is there a law that provides that the indemnity shall be 50,000 in case of death? There is none. In fact, it's only 3,000, but the 50,000 there is based on decided cases. And if it is qualified, 75,000. Loss of earning capacity of the deceased. It shall also be included. Support in favor of the person to whom the deceased was obliged to give. And then moral damages for the mental anguish in favor of the spouse, descendants and ascendants, and exemplary damages in certain cases. So how do we, how about rape? It's 50,000. If rape with homicide, 100,000. And what are the other damages recoverable in rape with homicide? You have their civil, moral, temperate, exemplary damages from People versus Gumimba. Okay, so how do we compute loss of victims' earning capacity? So you have there the formula, net earning capacity equals life expectancy times gross annual income less the living expenses. So based on the American expectancy table of mortality, our life expectancy is age of 80. Okay, 80. So you have there 2/3. That is the fixed factor. So 2/3 times the life expectancy minus the age of the deceased at the time of his death. Okay, time of his death. And then pasayop na ko. Sa life, this is the life expectancy itself. So sa life expectancy, that would be 80 times the actual age. Let us say he is 30 years old at the time of his death. That would make 30 as his life expectancy. Or nabalik ko. Based on my example, 50 years old. So, no. 30 years old. So, life expectancy is 50. Now, living expenses is estimated to be 50% of the gross income. So, if you are earning 10 million, so your living expenses is half, so that makes it 5 million times the life expectancy of 50, so that would make it 1 million, the net earning capacity of the deceased. Obligation to make restoration, reparation, and indemnification, to whom it devolves. The obligation to make restitution or reparation of damages and indemnification of consequential damages devolves upon the heirs of the person liable. The action to demand restoration, reparation, and indemnification likewise descends to the heirs of the person injured. Okay, so they will be substituted. So the heirs of the person liable has no obligation to restore, okay? If not possible and the deceased left no property. So in other words, the provision of the law is only possible if the deceased person, the deceased accused, left properties to answer for the civil liability. Thus, if A stole a ring, which he later sold to an unknown person, and after A's conviction by final judgment, A died, but he left no property to meet the reparation. A's heirs cannot be made to repair the damage, but if A left property, the heirs may be required to pay out of the proceeds of the property of A. The same thing may be said with respect to indemnification. So as a rule, civil liability is possible only when the offender dies after final judgment that is based on delict. If he died prior to final judgment, then there is no basis for the civil liability from the delict. Remember Article 100. So since the criminal liability of the accused, since he died prior to the finality of his conviction, for example, then you cannot make him civilly liable based on the delict alone. If there are 2 or more persons civilly liable for a felony, the court shall determine the amount for which each must respond. Okay, they must share the civil liability. To illustrate, The court awarded a civil liability of 6,000 to be apportioned as follows. Principal shall be primarily liable for 3,000. The 4 accomplices shall be liable primarily and in solidum among themselves for 3,000. Okay? In solidum or solidary liability, the law provides that in case of insolvency of the accomplice, the principal shall be made subsidiary liable for their share for the indemnity. And in case of the insolvency of the principal, the accomplices shall be subsidiarily liable jointly and severally from the indemnity due from the said principal. So when we say jointly and severally, that is just synonymous with solidum or solidary liability. When there are principals and accessories in the commission of the crime of theft of large cattle valued at 200, the principals are solidarily liable for 150, which represents their quota, and subsidiarily liable for 50, representing the quota of their accessory. The principal is primarily liable for his own part of the indemnity. The several accomplices are jointly and severally liable for the portion adjudged against them and are subsidiarily liable for the portion of their principal in case of the latter's insolvency. Simply put is that if you have there more than one accused, the liability there shall be paid by them, like here, considering that their participation is not the same. So the court there had it in proportion. So if you are all principal, automatically divided by 3 to come up with the whole, to cover the whole civil liability. So if it is solidarily liable, if you have their A, B, and C, they are liable for 6,000. In other words, 2,000 each. But the private offended party can go after any of them, and that accused who paid can ask for a refund from the other accused, because the private offended party can ask the whole amount from anyone. So that is if it is solidary liability. If it is joint liability, to distinguish it from jointly and severally and in solidum or solidary. Joint ragyod, only joint. And you have their A, B, and C. The private offended party can go after any of them according to their portion only, but not the whole amount. Any person who has participated gratuitously in the proceeds of a felony shall be bound to make restitution in an amount equivalent to the extent of such participation. Now take note of the term gratuitously. The person who participated gratuitously in the proceeds of a felony referred to in this article is not criminally liable. You cannot make him criminally liable because he is not part. In fact, he does not know that it was a proceeds of the crime. If the person who participated gratuitously in the proceeds of the felony knew that the property came from an illegal source, he is an accessory. So if he is, and he is not only civilly liable, he also is criminally liable. But if he really does not know and he was able to benefit from it, so we call that as a gratuitous participation. So under Article 111, he cannot be made criminally liable but only civilly liable. He received it for free. He received it for free. So that is 111. If with a fee, meaning to say, he put something in order to be in possession or to receive it, then the article applicable is Article 105 and not 111, because 111 refers to the gratuitous participation of a person. To illustrate, A, after stealing a diamond ring worth 1,000, gave it to B, who, not knowing the illegal origin of the same, accepts it. Later, B sells the ring for 500 to a foreigner, who immediately leaves the country. As the ring cannot be returned, the remedy available to the offended party is to obtain from the offender the reparation equivalent of the value of the ring. In case A is insolvent, B shall be subsidiary liable in the sum not exceeding 500, which is the gratuitous share in the commission of the crime. The fortune of the innocent person must be augmented by his participation in the process of the crime. Hence, in the specific previous example, because he enriched himself in the amount of 500 by the process of selling it to a foreigner, that is the amount to which he shall also give in return. It is necessary that his fortune has been augmented by his participation in the process of the crime. If he merely participated in the eating of the stolen property, he is not obliged to make restitution because his fortune was not enhanced thereby. So only if his fortune is enhanced. Extinction and survival of civil liability. Civil liability established in Articles 100, 101, 2, and 103 of this code shall be extinguished in the same manner as obligations in accordance with the provisions of the civil law. So what are the mode of extinguishing civil liability? By payment or performance, if any. Loss of the thing, condonation or remission of the debt, confusion or merger of the rights of the creditor and debtor, by compensation, by novation. So actually, you have this in your civil torts and damages as well, also in the civil code. So these are the same civil liability that we are referring to. Other causes might be annulment, rescission, fulfillment of a resolutory condition, and prescription. So in other words, if the person is criminally liable, hence he is also civilly liable. So aside from the fact that the court imposes upon him a straight penalty of 1 month imprisonment and required to pay 500, the payment of 500 extinguishes his civil liability. Or if he is required to return the thing, by the actual returning of the thing, then the civil liability is extinguished. Loss of the thing, meaning to say, you cannot make any return anymore because of the loss of the thing. So you have nothing to return. So probably since reparation, restitution, reparation cannot be done, restitution sets in. And then condonation or remission of the debt, meaning to say, it could be possible that the offended party waive or condones the civil liability of the accused. Or confusion or merger, meaning to say, it could be possible that, how could this be possible? Rights of the creditor and debtor, meaning to say the accused and the offended party are debtor, creditor to each other, then they might as well had it agreed with it as to terminate the responsibility, each responsibility. Compensation is to pay, or novation. So there is a change on the mode or manner on how the same shall be paid. So that would be possible. So you will have more on this when you will have your in your civil law. 113. Except in cases of extinction of his civil liability as provided in the next preceding article, the offender shall continue to be obliged to satisfy the civil liability resulting from the crime committed by him, notwithstanding the fact that he has served his sentence consisting of deprivation of liberty or other rights, or has not been required to serve the same by reason of amnesty, pardon, commutation, or sentence, or any other reason. What do we mean by this? That while the penalty of imprisonment might be served out by the accused, or he was granted pardon in such a way that he was not required to serve the sentence anymore, or it was shortened because it was commuted by the chief executive. At any rate, the civil liability survives. Okay, even if the accused was granted probation, because those are for the criminal aspect of the case only. The civil liability is different. Now, in the decision, the accused shall be sentenced to suffer imprisonment. So, penalty of imprisonment, that is for the transgression of the law or the transgression of the peace of the society he commits, of the social injury that he commits. While the accused may be required to serve right then and there when his service is considered to be final already, if the accused cannot pay, you cannot actually compel him. So it is on the paper that aside from the penalty of death, penalty of imprisonment that the accused has to serve out, there is also that award of civil liability. But if the accused has no means to pay, you cannot force him. But maybe later on, after he will be out of jail, or let's say after many years, because the law did not actually provides for a limitation, or it could possibly that after you will discharge or release from imprisonment, you won in the lotto, you will be required to pay because civil liability survives. Okay, so let me end this lecture by saying that thank you. Thank you for allowing me to be part of your law journey. I am grateful that despite of our limitations, the challenges that we are in, you made it through. Just a piece of advice. If there are still so many things, because I cannot also expect you to absorb everything, keep on reading. Read back your book. Read back Reyes, because Reyes is a good book. I want you to know that until now, I am still reading the book of Reyes. Okay, so there is no substitute in reading. Knowledge is unending. Keep on learning. And I wish you good luck and God bless. And may God guide you as you achieve your dreams of becoming a lawyer. Thank you.